Good morning, everyone. We're going to call this 10th meeting of the Special Legislative Committee on Bill C32 to order. And for the first hour, we have witnesses from the Business Coalition for Balanced Copyright, Jay Kerr-Wilson, and also from the Canadian Chamber of Commerce, Perrin Beatty and Lee Webster. So we will start with Mr. Kerr-Wilson for 5 minutes. You have the floor.
Thank you very much, Mr. Chairman. Members of the committee. My name is Jay Kerr-Wilson, and I'm here today on behalf of the members of the Business Coalition for Balanced Copyright. Thank you very much for giving us the opportunity to present our views on Bill C32. The members of the coalition include individual companies and trade associations representing a broad spectrum of the communications, technology, broadcasting, retail, and internet industries. The one thing that our members have in common is that they provide the essential links between creators and consumers. The issues addressed in today's presentation are those on which there is agreement among the coalition members. Some individual members may wish to address additional questions or concerns when they appear before the committee on their own behalf. We believe that Canada's copyright laws should focus on two fundamental and interrelated objectives. First, to deter infringing activity, and second, to promote open and efficient markets for legitimate distribution of copyrighted works. We disagree with the notion that copyright legislation is either good for consumers or good for creators. We believe that by promoting the development of a vibrant digital economy, a balanced approach to copyright legislation can serve the interests of creators, distributors, and consumers. We also believe that Bill C32 goes a long way towards striking this balance, and we support its passage in a timely manner. This doesn't mean the coalition thinks the legislation is perfect or couldn't benefit from some minor changes to provide greater clarity and certainty. In fact, we have submitted a number of proposed changes that we would like the committee to consider as part of its review. First, Bill C32 provides limited liability for content hosting services. The ministers have repeatedly stated that these provisions are intended to remove barriers to the introduction of innovative remote storage services, including cloud computing and network PVRs. We are concerned, however, that while the existing language limits liability for the reproduction of a work that is stored using such a service, it still leaves potential liability for any transmissions of the hosted content, even back to the person who posted it in the first place. Second, Bill C32 would create liability for those people that enable others to engage in copyright infringement. We support this provision as an important tool for rights holders to protect themselves against the widespread unauthorized distribution of their works. We are concerned, however, that the provision as drafted does not adequately distinguish between those individuals that provide services intending that those services be used to infringe copyright and innocent actors who merely promote or encourage, who merely provide links to internet sites, but who do not actively promote or encourage infringement. We are also sensitive to the concern of rights holders that only prohibiting those services that are primarily designed to enable acts of infringement may be too narrow. We therefore support amending the provision to prohibit those services that are designed or operated primarily to enable acts of infringement. Third, we support providing legal protection for technological protection measures, or digital locks. However, we do not believe that the use of digital copy control locks should prevent consumers from relying on the personal use exceptions such as format shifting or time shifting. Fourth, we support the provision that would permit broadcasters to transfer musical works onto a different format for a limited time without incurring additional copyright obligations. We believe that a similar amendment should be made to the provision that lets local television stations and community channels tape live events such as parades and concerts for later broadcast. Fifth, we support the provisions that would impose on ISPs the obligation to implement a notice and notice system. Many Canadian ISPs have engaged in a voluntary notice and notice system for several years, and other countries are now beginning to adopt similar obligations. However, we are concerned that the bill would not provide any time for ISPs to implement the additional obligations that would be imposed by the legislation. We recommend that the notice obligations only come into force once the Minister has enacted regulations prescribing the forms of the notice and the fees that can be recovered, and after a sufficient period for ISPs to implement the necessary systems to comply with all of the obligations. 6, we support the inclusion of an exception for user-generated content. However, we have heard the concerns expressed by rights holders about the potential for abuse of the exception as drafted. Therefore, we agree that the provision could be amended to require that any use of the works in user-generated content be fair, in addition to the conditions that have already been proposed. Finally, we strongly oppose the introduction of new levies or the extension of existing levies to cover private copying on digital devices. We recognize that the bill does not deal with the private copying levy, but we are aware that the issue has been raised on several occasions before the committee. From our perspective, there are insurmountable problems with such a levy. Thank you for giving us the time to present these recommendations, and I look forward to answering any questions you may have.
All right, thank you very much. We'll move to Mr. Beattie.
Great. Thank you very much, Mr. Chairman. I'm delighted to be here, and I'm very pleased to have with me Mr. Lee Webster, who's a partner with Osler's and who's also the chair of the Canadian Chamber's Intellectual Property Committee and a member of the Canadian Intellectual Property Council. Mr. Chairman, our members see the bill as a piece of the larger puzzle of innovation in Canada. Many companies, big and small, rely on the protection of intellectual property rights to maintain their businesses. Updated copyright legislation will bring Canada in line with other major industrialized countries and establish rules of the road for downloading and file sharing on the Internet. It will also position Canada to finally ratify the WIPO Internet treaties that Canada signed in 1997. Certains disent que le projet de
Some would say that Bill C32 will prevent Canadians from listening to music and watching movies on their own portable devices. That is false.
Stop people from enjoying their media, but rules do have to be established so that illegal commercial operations are stopped. What we need is to establish a marketplace framework that will support development of new digital products, services, platforms, and business models, and make it clear what kinds of behavior are legitimate and what kinds are prohibited. We have to strike a balance between the interests of consumers and those of rights holders. Generally, we believe the government has done a good job in striking the right balance, and we support the principles of the legislation. I can certainly tell you, Mr. Chairman, that striking the appropriate balance to establish good public policy is not an easy task. I can commiserate because I had the responsibility for the copyright file when I was Minister of Communications in the early 1990s. Both the Conservatives and the Liberals put legislation on the table in recent years only to have the bills die on the order paper. We're anxious to see this new bill passed to clarify rights and responsibilities for both businesses and consumers. So perhaps the third time's a charm. Now, strong copyright protection will benefit communities across Canada, and here are some examples. In Toronto, there are over 3,300 high-tech companies generating revenues over $32.5 billion annually and employing 148,000 people. In Kitchener-Waterloo, there are over 700 high-tech companies generating $18 billion annually and employing 30,000 people, with over 200 burgeoning startups. The Canadian video game industry generates billions annually and employs over 14,000 people across the country. Many major studios are in the Montreal areas, such as Ubisoft and Electronic Arts and Behavior. Well, St. Catharines is home to prominent video game company Silicon Knights, which employs over 100 people in high-value jobs.
In 2009-2010, the film and television industry in Quebec was assessed at being $1.2 billion annually and responsible for creating over 36,000 jobs in that province.
Of the future. Properly applied IP rights drive job creation, economic growth, and innovation. As I mentioned, copyright is only part of the puzzle. Patent and brand protection and promotion is also a key element in attracting and retaining businesses in Canada. Leading economies around the world have made IP protection a priority. Japan has created an IP strategy council led by the Japanese Prime Minister. In France, President Nicolas Sarkozy heads an anti-piracy commission to curtail internet piracy. Clearly, other nations are effecting major changes in IP protection. If Canada does not soon follow suit, Canadian businesses risk being left to the periphery of the global economy. By defining and better protecting IP rights, we'll develop a marketplace that rewards investments in innovation and creation. It will foster new business models that will lead to stronger economic growth, to job creation, and to prosperity. In modern developed nations like Canada, where services and innovation have become key economic drivers, and given our emphasis on the knowledge economy, doing so has never been more important. Let's fix the unintended consequences in the drafting of the legislation and get this copyright bill passed. It's desperately needed to provide certainty to Canadian businesses. And, Mr. Chair, I simply plead with the committee this way. Let's not let the perfect be the enemy of the good. This represents our best chance to modernize. I think it was Mr. Angus. I was looking at some of the comments that were made in Parliament and elsewhere. I think it may have been Mr. Angus who had made reference to the WIPO treaties reaching back into the past century. I was reminded of George Michael's CD, Songs from the Last Century. What we're talking about here is principles to update from the last century and to bring us into the 21st century. And it's something that's critically important. Now, since our time is limited for opening remarks, Lee will get into specific areas where we need amendments during the question period. But just to put it very simply, we need to see some clarifications or improvements in the areas of enabling infringement, encryption research, computer and network security, interoperability, reverse engineering of software, user-generated content, online service provider liability or safe harbors, private copying and backups, and statutory damages. Thank you, Mr. Chairman, and we'd be very pleased to respond to questions.
Thank you very much. We are now going to move to the first round of questioning. It's going to be 7 minutes, and we will hear from the Liberal Party, Mr. Garneau.
Thank you very much for being here this morning and for giving your testimony. I'd like to start off by focusing on TPMs, or digital locks, and the issue of the bill as it currently exists, which of course says very clearly that if you circumvent an existing digital lock, you are breaking the law. Now, the Liberal Party is very clear on its position that it agrees that if you are circumventing a product with a digital lock for commercial purposes, pirating or what have you, that is breaking the law, and we are against breaking the law. However, we do have a different position with respect to people buying a product and format shifting, copying, transferring it to another personal device for their personal purposes. We've been clear on this since C60, one of the predecessors of C32. I'd like to start with Mr. Kerr-Wilson on this issue because he referred to it briefly in his opening comments. Would you please, and then Mr. Beattie, would you please explain your position with respect to the use of a product with a digital lock, but in the case where it is strictly for personal purposes?
Thank you very much, Mr. Garneau. The Coalition's position is the same as the one you just articulated. We support protection for digital locks, and we support prohibiting breaking the digital locks for an infringing purpose. But we also believe that digital locks should not prevent consumers from making legitimate uses of content they have legitimately acquired. So our preference would be that the personal use exceptions not be subject to the digital locks. In an effort to try and find balance, we've modified our position somewhat because the Act actually defines two distinct types of digital locks: copy control locks and access control locks. And in the general provisions, only circumventing access control locks is prohibited. There is no general prohibition against circumventing a copy control lock. So what we've said is, for the personal use exceptions, which by and large involve copying, that it should be not prohibited, or it should be permissible to circumvent a copy control lock in order to make your backup copy or to do a time shifting, but that perhaps keeping the access lock protection in place would be a middle ground that would give rights holders some more certainty. But in principle, we agree with the position you've articulated.
Thank you. Mr. Beattie?
Thank you, Mr. Chairman. Mr. Garneau, thank you for the question. We do have concerns about opening up the capacity to break digital locks, in that the impact of that could very well be to limit the options that are open for various business models and the range of opportunities that consumers may have. There are a number of businesses that rely upon the ability to have digital locks in place as it relates to individual consumers. One thinks for example, of rentals of movies digitally. If it's possible to circumvent that, it creates a problem. You'll find content providers simply pulling the content back and not making it available. And we run the risk in Canada then of limiting consumer choice as a perverse effect of something that was intended for good purposes. But let me turn to Mr. Webster, who's our expert on this.
Okay, thank you very much for the opportunity to speak today. The Chamber's position is that we do support digital locks both for access and for copy controls. You know, I always think that some of these supposedly complex internet-based issues can be sort of pushed back on, you know, the way things are dealt with in the bricks and mortar world. You know, it's illegal for somebody to walk into my house and walk out with my sofa. That's fine, but that's not a reason for banning locks on my door. I think a digital lock is appropriate. It's the consumer marketplace. If the consumers don't like digital locks on the product, they have the option not to buy it. If they want to change the commercial model, they can complain to the rights provider. But allowing for persons to break these locks, it'll have unintended consequences. So I think the marketplace should dictate it. I think it's basically a property right to keep the digital lock on the software, and if the consumers don't want it, they have recourse to complain to the rights holder.
Thank you, Mr. Webster. On the issue of mashups or user-generated, am I to understand, Mr. Kerr-Wilson, that what you're saying is that perhaps mashups should be transferred into that other group that is in the C32 bill at the moment, satire, parody, education, as an exemption under fair dealing? Is that what you're proposing?
Well, I mean, technically you can either move the user-generated content exception into the Section 29 general fair dealing provision, or you could simply make reference to fair use in the provision as it's drafted now, because I think you want to keep the conditions that are in there now that talk about effect of the mashup on the market for the individual work. You want to keep those market protections, but I think it's also appropriate that any use be fair and then incorporate the factors, the fairness factors that the Supreme Court has identified.
Thank you. And again, Mr. Beattie, your position on mashups?
Yep. Again, it's a question of balance here. We understand that mashups should be allowed to an extent, but what we don't want to do is have something that's so broad that allows somebody to do essentially anything that the original creator could have done with the product. So it's a matter of striking the balance. Mr. Webster?
Yeah, thank you. Let me drill down a little bit on that. Our position is that this should not be allowed with respect to subject matter like technological subject matter like computer programs and engineering drawings. You know, the user-generated content exception we think is unique. I don't think that there's a similar provision in other countries. Having said that, we think it's a good idea with some amendments. For example, mashup should not be created if there's an adverse financial effect on the rights holder. They should not be permissible if there's an agreement with the rights holder that this type of activity should not be done, and intermediaries should not be allowed to have a financial benefit from these mashups.
So you're saying it should be further defined?
Correct. Well, you know, in principle, we would agree with it, but I think it needs a little bit of fine-tuning to make sure that you know, unauthorized third parties don't make unfair commercial advantage out of it.
Understand. I want to go to my third question before I run out of time. Statutory damages, as written, as proposed in C32, what do you think of the statutory damages, the amounts and the way it's written? Again, Mr. Kerr-Wilson.
The Coalition has not taken a position on the statutory damages, so I will turn it over to our friends.
We see them as very valuable tools to enable people to be able to enforce their rights. Again, let me turn to Lee to elaborate on that.
Not so much of whether they're a good tool, but are they appropriate? Because there's some controversy about whether they're appropriate in terms of the amounts that are being discussed, whether they're commensurate with the seriousness of potential offenses.
I think part of the problem here is we all see what's gone on in the United States with some of the rights holders getting massive damage awards from individuals, and I don't think that's a fair way of dealing with things. Having said that, though, you know, you look at the numbers for personal infringement in the statutory damages provision, it's $100 to $5,000. We think that's good with one problem. The problem is that we're concerned about it being really a license for somebody to infringe. I know $5,000 is a lot of money to most people in this country, but having said that, you know, what if somebody downloads a gigabyte of music, tens of thousands of songs? Is $5,000 a deterrent to that? I think not. And also, too, there's some uncertainty with respect to, you know, it's not just commercial uses of downloaded music. You know, some individuals like to disseminate music just for the heck of it, frankly.
Okay, well, we're going to have to move to
Sorry,
Bloc Québécois.
Thank you.
Madame Lavallee, pour 7 minutes.
Merci beaucoup.
Thank you very much, Mr. Chairman, and good morning, gentlemen. You all represent businesses, big businesses, business people. Mr. Beattie, you're the president and CEO of the Chamber of Commerce. So you know how to talk business, you know how to talk money. And we also represent small and medium-sized businesses, yes. And they all have in common this: in order to conduct a good business and in order to have the best type of business, everyone has to be in a win-win situation. So providers have to have an advantage, consumers have to come out winners, businesses have to come out winners. So I think you would agree with me on that, Mr. Beattie, that everyone has to benefit. And I know why you're happy with C32, because despite the title of your business, Mr. Wilson, or your coalition, the bill isn't particularly balanced. And I'll take a few minutes to explain why. For example, the creators, content creators, are the biggest losers in this bill. They're not updating this bill properly, so they are losing about $13.8 million per year because of the exceptions. They're losing about $40 million because of time shifting. And I'm taking shortcuts here because I know you're familiar with the bill. But because of time shifting, there's about a $21 million loss. And I read somewhere that it could be even greater. So that's about $74 million per year. Now, let's take user-generated content. In France, there are no exceptions. And the French Association for Writers and Composers have negotiated a royalties agreement or levy agreement because a lot of money can be lost. So we're talking about $74 million on an annual basis that creators and artists will lose under Bill C32. Do you think that's balanced? I don't think that's balanced, and you who know how to talk about money probably realize that too. We're not talking about grants here. We're talking about money that's been taken out of their pockets. Yesterday at the Heritage Committee, we heard from the Department of Canadian Heritage, for example, and there were many people around the table, and the question I asked was this: how do artists gain from this? Tell me, what financial gain will they make from this bill? Because, yes, there are a few extra rights for performers, but here it is not a financial gain. So they're losing $74 million a year, and they only earn about $23,000 a year. So how can they make more money? There is no way of making more money. Now, creators are also providers in a way. They are the ones who fill up the internet with this content. 80% of content on broadcasting stations is made up of music. Now, when they can no longer produce because their money has just been cut off, their lifeline has been cut off, what do? Does that mean that radios are going to go to the States to get their content? And we have Canadian and Quebec consumers. And how will they react then when they see that? If we're going to listen to American music, well, then we might as well use American broadcasters. And so consumers will switch channels. So I'm showing this problem to you. There's a lack of balance. I know you're highly intelligent people. You're familiar with business. You know the value of money. You know what it means to be able to turn a situation into a profitable one. So I'd like to hear your comments on this.
And I'll answer in English if that's okay, just so I can make myself better understood. I would respond a couple ways. And the first of all is the Act creates, as it exists now and as it would be amended by the bill, creates the same rules for everybody. So whether you're a large corporate rights holder or a small individual creator, the same rules apply to everybody. And the same holds true for Canadian creators and non-Canadian creators. We have an obligation to provide the same level of protection to everybody. So when you talk about the lost revenue, and I'm not familiar with the figures you cited, certainly I'm not aware of any lost money through a time-shifting exception, because right now people can use a VCR or a set-top box or a computer to record television shows, and there's no revenue associated with that. So I'm not sure the bill is going to cost anybody any money. But I think the more fundamental point is using the Copyright Act to try and sustain some minimum level of income for creators, which I think is a laudable goal and a good public policy objective, has some problems because the bill applies to everybody. So if you create a measure hoping to provide some moderate level of income to Canadian artists, the way the provision will be applied, most of the revenue generated won't go to Canadians. It will go to large corporate American rights holders, which have the bulk of the market in the U.S. So from our perspective, we should set ground rules in the Copyright Act that allow creators to market their creations, to benefit economically. And then on top of that, if we think Canadian artists, because we live in a smaller market and they have a much different, more difficult economic challenge, require additional support, then as a matter of public policy, we should do that directly, because we can't target support for Canadian artists through the Copyright Act, because most of the money will simply go to creators from other artists and to those who already get the most airplay, the most CD sales, the most ticket sales.
Je m'excuse, je vais juste faire une petite correction. Effectivement.
Perhaps I could just add a clarification. There are measures in the bill that remove revenue from artists that they already have. Let's take a simple example. Let's take the issue of time shifting. Broadcasters spend several $1 million a year on this. And perhaps when you leave, I can show you the section. What happens is that under this bill, that money cannot be paid to the artist. So that represents a lot of money for the artist. But I'd like to give the other witnesses an opportunity to respond.
I can hear the passion in your voice when you talk about artists, and a passion which I share as the former Minister of Communications for Canada responsible for Canadian culture, et comme l'ancien président de Radio-Canada.
The former president of Radio-Canada.
Responsible for bringing in the Status of the Artist Bill, which was designed to help to provide protections and income for artists. Copyright protection is one of the tools, not the only tool, but it's one of the tools that the government has at its disposal to provide for better incomes and better support for creators. And this is why we support the legislation. Artists themselves will benefit from having better copyright protection. Businesses will, others will as well. There are other tools in addition to that, as you're looking at the income of artists, support that there may be available for the artistic community, that government also has at its disposal and should look across the board at all of those measures. Of concern to us, though, as we look specifically at copyright, where we believe that both artists themselves and the businesses that are involved with them will benefit, is that we not lose this best chance that we've had to modernize our legislation and to move ahead. The one area, and I've read the committee's transcripts, the one area where there's agreement is the status quo is unacceptable. We have to make improvements. It is a balance that we need to strike to find some sort of fair middle ground. We think that a conscientious attempt is made to do that. We're making proposals and ways to improve it beyond that, but we think that can be done. Mr. Webster might want to comment specifically.
Je veux juste prendre mes 10 dernières secondes, Monsieur
We're going to have to move on.
Juste 10 secondes, OK?
No, Mr. Angus for 7 minutes.
Thank you, O long-suffering chair. And have I told you lately what a good job you do with this task? Thank you, gentlemen. This is fascinating. I'm very glad to have you here. It's what we always hear now is that this is about balance, and everyone who comes to us says, listen to me because I've got the balance and the other guys are unbalanced. And it's something I've noticed. I've found two interesting perspectives on copyright. Mr. Webster, you tell us it's about stopping people from stealing your sofa, that it's a property right. Copyright isn't a property right. Copyright is a construct of Parliament going back all the way to Queen Anne's law that was designed as a public good. And the good was to remunerate the artists and to allow a public good and to decide the limits on that. It's not that you own a house and you pass that house on to your kids. And Mr. Wilson, you're describing copyright as a laudable goal for Canadian artists, but it's not the Canada Council. The fact that I pay into copyright, I don't care that Bono's going to make a lot more money on Canadian radio than Sarah Harmer. Copyright is fundamentally about ensuring that artists get paid. Otherwise, there is no business model. So when you say we shouldn't worry about updating the levy, we've got some $41 million directly in musicians' royalties that will be lost from the mechanical royalties that are going to be tossed out for the if we don't update the levy in some form of digital format. That's a serious amount of money, not counting the other areas that artists are going to lose. So don't you think that there is some obligation, if we're going to talk about copyright, that it's actually about people getting paid for their work at the end of the day?
Yes, Mr. Angus, I agree, and I'm glad you asked the question because I think it also will address Madame Lavallee's question, because when she was talking about time shifting, I think I misunderstood and thought it was the recording television programs, and I think she was talking about the ephemeral as well. So I have a couple points to make in response to your question. I'll try and make them quickly. First, on the specific question of the ephemeral exception and the ability of radio stations to make copies, as the provisions now stands, the lifespan of those copies is 30 days. So if radio stations want to make persistent copies of music to use as part of their operations, they can't now rely on the exception to do it. And if amended, they can't rely on that exception to do it. They need to have some other mechanism to have long-term copies. This is simply short-term copying. But I absolutely agree with you. The fundamental purpose of the Copyright Act is to provide rights holders with the protections they need so they can derive revenue from their creations, so they can see a return on their investment. But even going back to the date of Queen Anne, that revenue was through agreements, through contracts, through going out to the market, making deals with publishers, and then when we finally got to the recording industry, making deals with the recording industry, and then consumers would place the value that they want on the works. And when we talk about the levy, the problem is there's a very large disconnect between what the levy would be used for and what the levy would be collected on. So, the days of the single-use digital music player are gone. Everything's a multi-use device. People want their phones and their internet access and their music players and their cameras all in a single device. So how do you charge a levy for music on a device that may never see a song embedded on it, such as mine, which can take music but doesn't? The other problem I have with it is the coalition wants to see artists succeed in a new digital economy.
Which coalition? Are you talking about their coalition?
Sorry, our coalition.
Oh, sorry. I just thought you were going to go after the socialist separatist bloc. Whenever we talk about levies, that's my guys, they get all excited. I've seen them just gyrating over
We may need to rebrand. But we have distributed to the committee members a copy of the license that online music services such as iTunes are required to pay to authors and publishers in order to make copies. And we've highlighted on the first page of the levy the part that says this tariff, which is a payment to rights holders from online music services, entitles an online music service and its distributors to authorize consumers in Canada to further reproduce the musical work for their own private use. So when someone buys a song for iTunes, they're already paying for the right to move it onto their computer or to move it onto their iPod. So the levy would actually require those consumers to pay twice. Once when they buy the device, and then pay again when they pay for the music.
We're not going to get too much into this, but if you looked at the Copyright Board decision, contrary to what my colleagues over there say, it doesn't get applied to cars, it doesn't get applied to cell phones. It has to be very specific in terms of the playing device, and the revenue that we're looking at is $35 million, and that's a shortfall. And I got to go back to artists in my region and say, and across Canada, we're giving you a copyright bill, and we're telling you, lump it, live off iTunes. I got songs on iTunes, I tell you, that doesn't cover 1/50th of what's being copied out there. So we have to find a copy mechanism. But I have to move on because I want to speak with you, Mr. Beatty. I'm glad that you read me in the House on WIPO. I might have said that it was written when the fax machine was cutting-edge technology. I think that was my full quote. And I'm worried that when we talk about WIPO, we're applying elements to WIPO that are not necessarily there. For example, the technological protection measures in the original WIPO treaty. And if you look at WIPO-consistent countries, in recent analysis, we look at many of our WIPO competitors, and they have exceptions on technological protection measures, because under Article 10 under the Copyright Treaty Act, it says that it is possible to carry forward into the digital environment the limitations and exemptions that national laws have considered acceptable. So, for example, if we give someone the right of parody and satire in a non-digital world, and that exists in a digital world, do you not believe it's possible for us to, I know it's difficult and it might be problematic for some, but that we can establish a made-in-Canada law in terms of technological protection measures that allow us in Parliament to set the exemptions, and that we are still WIPO compliant. So we're very much with that treaty of 1996.
Thanks, Mr. Angus. I'm not a lawyer, and I'll spare you my legal opinion. As a result, I'll turn to Mr. Webster. The only thing that I will say, based on your previous question, that notwithstanding the fact I was here a long time ago, Queen Anne had actually passed along before my days, so I didn't have a chance to discuss it with her, but Lee is no doubt up to speed on all of that, and I'll turn to him.
Thank you. You touched on a number of topics, but I think the bill as it is WIPO compliant. Certainly we can craft exemptions to it if we wish to do it. The question is whether we wish to do it and whether it's appropriate in the circumstance. Now, I don't want to get into arguing with you over whether my sofa is akin to a copyright, but copyright is an intellectual property right, and the reason we have an intellectual property right is twofold. One, it's to reward creative efforts, and two, it's to stimulate creation. We're sitting here, the Chamber represents not just big business, but also little business. But copyright goes back to the authors and the creators. The reason we have copyright is to reward creativity. So, if we talk about striking a balance, that's fine. The balance we have to work at is how much reward to give to the creators and authors, and that's why we're all here today, and that's why the legislation needs to be updated. So one thing we should not have is any misconception that copyright is just something to enrich the pockets of big business. It goes back to authors and creators. That's the fundamental foundation of the right. So how far does the right go? We now have an opportunity to make changes, to look at this, to see what's appropriate in the digital age. So I think
because I think we all agree. We want to make sure that if you invest a serious amount of money into a product, that it's not going to be bootlegged and stripped apart. The question is if there are specific exemptions that are guaranteed under Canadian law. You say let the market decide. Well, I don't see how you can decide legislation and say you have rights, but some corporate piece of software is going to deny specific rights that you should be able to access. For example, parody and satire.
That's going to have to be it.
Well, part of the problem with this is unintended consequences. And, I was practicing law back in 1997 when we went through the last round of amendments. And I know there was a lot of talk focused on, dual digital cassette decks, basically. My dual cassette deck went out in the garbage about a month ago. Okay, we didn't think in those days of Napster, iPod, or anything at all like that.
We're going to have to
try to craft
and move on to Mr. Del
exceptions.
Mastro. I'm sorry, we're well over this round. Mr. Del Mastro for 7 minutes.
Thank you very much, Mr. Chairman, and thank you to the witnesses for appearing today. I think this is frankly, it's a contrasting testimony to what we had the other day. It's somewhat refreshing. I think, with respect to the numbers, Mr. Kerr-Wilson, I'm not surprised you're not familiar with some of the numbers that are being thrown around today. I think for future committee hearings, I'm going to have the chair bring in the big wheel off the Wheel of Fortune, and we'll just spin it, and whatever it stops at, we'll suggest that could possibly be a number that might be impacted by the bill, because I have no idea where these numbers are coming from, and frankly, they're very difficult to, even when we ask folks to quantify it, it's very difficult for them to actually quantify where the numbers came from, so I'm assuming it's a big wheel that you spin. So anyhow, Mr. Beatty, you made a fantastic comment when you said, let's not let the perfect be the enemy of the good. I can't agree more. I think that based on the consultations that we've had across the country, we've met with members, frankly, of the Chamber of Commerce, big and small, And there was a comment made the other day that this bill seeks to protect big copyright holders but does nothing for small copyright holders, does nothing for small business. And in fact, we get bogged down a lot talking about artists on this committee, but what we're really talking about is creators of all different forms of intellectual property. Some of it is music, some of it is art, some of it is photographs, in fact, which are now protected in this bill. Some of it are things like software that's created, gaming software, software for computers and business. These are all the types of things that are protected, creators, big and small, protected in this bill. It's a good bill. I've seen your amendments, by the way. I think they are largely technical amendments that involve making sure that the intent of the bill and the actual function of the bill in law is in line. And I think that I would describe them largely as technical amendments that you're suggesting. So if we're not going to let the good be the enemy, or the perfect be the enemy of the good, and your association, I'm assuming, you must be here representing big and small and creators of all forms. Is that accurate?
Yes, we are. In our network, we have 192,000 businesses. The vast majority of them are small and medium-sized businesses, and both larger businesses and smaller ones will benefit from this legislation. I guess the only pitch, just going back to your question, I would make to you is, yes, we are recommending changes. I hope the government will be flexible on those. What strikes me, there's a lot of heat that's generated by the debate, and we see it in the parliamentary committee, you can see it in public comments get made, but I was struck when I was reviewing the evidence by the degree of consensus there is in terms of what the goals are that people on all sides are trying to achieve. And I think that if there's sufficient goodwill, that we can have a situation which is infinitely better than where we find ourselves today, where I cannot find anyone who says that what we have today is acceptable.
Yeah, I agree. And I think, frankly, the government's willingness to, frankly, work this bill through the process is evidenced by the fact that we're here at a legislative committee specifically set up for this copyright bill and to work this thing through. We're frustrated on our side because we feel that the bill is simply being punted down the field and not actually, we don't have the focus that we would like to see to have this bill accelerated and dealt with. How important is it to the Chamber of Commerce, and in fact, Mr. Kerr-Wilson, how important is it to the group formerly known as the Balanced Coalition for Balanced Copyright? How important is that we get this, that we deal with it promptly, and that this bill becomes law as soon as we can possibly do that?
Well, certainly.
How important is timeliness?
Certainly on behalf of the BCBC members, we think it's absolutely fundamental that the rules have to be established that create the framework for all Canadians to move forward into the digital economy, whether it's creators, distributors, and consumers. So, you know, we encourage the Parliament to work together, the parties to work together, to get the bill passed this time. As we would agree with Mr. Beatty's comments, that we can't let the perfect be the enemy of the good, especially when we've got regular review mechanisms built in so we can fine-tune and we can correct. But we need to take that first step and give the marketplace the tools it needs to develop.
Is timeliness an issue for your members, Mr. Beatty?
It sure is. And, you know, we've been waiting a long time. It goes back to my day when we were talking about this, and so many, you know, the technology has changed dramatically since the time when I was Minister of Communications. Various ministers have attempted to modernize our intellectual property regime. It needs to be done now desperately, and we can't just push it off, or else everybody loses. Everybody loses. The Canadian economy loses jobs, prosperity, artists, other creators lose, and we really owe it to them. This is our best opportunity we've had for a long time to modernize the regime, and we need to do it.
Thank you very much. I'd be interested in, obviously, being a chamber member, having been a chamber member for a long time. I'm just interested if the chamber has actually put any numbers to what they think, since we like throwing numbers out, what they think is actually being lost on an annual basis due to lack of protection in this country, due to piracy of copyrighted materials. Has the chamber quantified that in any way?
I'll turn to Lee on this again, but I would be it's very difficult to put that sort of a figure on lost revenues. You simply don't know exactly what's taking place and what people's behavior would have been otherwise. All we know is that it's substantial, and to a degree it's correctable. But
well, maybe I could just refine the question a little bit. If you can't quantify the loss, is anybody coming to you and saying we would invest more in Canada or we would invest more into our business if we felt better protected?
Yeah, absolutely. What we certainly hear from our members is that copyright protection is critical for them in looking at investments that they make in Canada. Do we have a regime that's attractive here or not? If I can talk personally just for a minute, my family was a manufacturing company. I'm not talking about copyright, but about IP here. And, we employed 800 people in the small town of Fergus. My grandfather at one point reportedly had more patents registered after his name than anybody else in Canada. That was an incentive to innovation and to job creation and to prosperity for Canadians. It is no different as you move away from patent protection to copyright protection. Having that sort of a framework in place rewards creativity, innovation, and risk. And people are going to go to, whether they're artists themselves or whether they're business people, are going to go where risk will be rewarded.
Thank you very much.
Move to the second round of questioning, and it's a 5-minute round, and Mr. Rodriguez.
Thank you very much. I think we all agree on the importance of having a modernizing this copyright bill, so you must have been very disappointed when you realized that it took 5 years to the government to start discussing this, and after prorogating 2-3 times. So I hear Mr. Del Mastro comment, but if it hadn't been of the prorogations, and we wouldn't, maybe we could have dealt with this a bit before. So I don't think the opposition is responsible for this. On est d'accord.
We all agree that the Act has to be updated, and we all agree that there has to be a copyright system that is solid and that complies with our international agreements. And we all agree that consumers have to be able to have better access to content. But where we don't agree with you is whether or not this content should be free, because what I'm hearing from you from the very beginning is that there are rights that existed and that generated revenue but will no longer exist, and that's fine. There isn't a problem with that. For example, private copying. Do you think a private copy has a value? Is it worth something? Monetarily, is it worth something?
To the individual, but that's one of the reasons when we're talking about technological protection measures, digital locks, that we think it's important that there be protection there that ensures that there's a range of options and business plans that people have that they can offer to consumers, and consumers can make a decision then as to what they would like to have.
But for the artists and the creators, let's take the example of music. They are also business people. I'm sure you agree with that. Each and every artist is, in a way, a small or medium-sized business. They are a business. They have a business, so they take risks. They have to work. They have to invest. They have to record. They never know whether something is going to turn out or not. But now we're telling this artist, when someone copies your music, it's no longer worth anything. You don't have a problem with that?
It's no longer worth anything, far from it. And the reason why we support copyright legislation is that we believe that intellectual property does have worth. The question is, how do you construct a regime to protect intellectual property that's modern, that's sufficiently flexible, and responsive to all of the needs that are there? The most important thing, in my view, that we can do for artists is to ensure that there are protections that don't exist today in terms of protecting their intellectual property. There are other tools as well, in addition to copyright, that the government has at its disposal to provide assistance to artists. And copyright should be looked at one of those elements that can advance the position of artists, in addition to the others.
Okay,
surely you agree that the fact that a levy doesn't apply to new technology involves a net loss of revenue for musicians and for creators. Now, I'd like to come back to the issue of ephemeral rights. You agree that that should be maintained as proposed by the government? That's what I understood.
Mais encore une fois, vous savez.
But you are aware that that represents a loss. I'm not pulling a number out of a hat. This is a number that exists. That represents about $21 million. And you don't think that's a problem, that that $21 million represents money lost to creators?
Dollar number comes from? Perhaps you could explain it a bit more.
C'est les chiffres qui sont.
Well, these were numbers that were provided by the music sector. This involves money that even goes to foreign artists.
The only loss will result, if we're talking about the radio station ephemeral, is if no radio station keeps any copies longer than 30 days. The existing provision only covers copies for 30 days. On the 31st day, they can't rely on the exception. They need to do something else.
Ouais, mais je comprends, mais ils vont faire.
Understand that. But they have a program, and that music may leave after 30 days. It may come back. I mean, they can just keep going around. And so there will be a net loss if the bill is maintained as it stands of $21 million.
Non, mais ce que je veux dire par là, c'est.
What I'm trying to say is this, because I agree with you on several points. Yes, it has to be updated. Yes, there are valid points to what you're saying, but there is also a loss of revenue to the creators, and you don't seem to be concerned. Mr. Cardet, you have 5 minutes. Thank you, Mr. Chairman, and welcome to you, gentlemen. I'd like to come back to what Ms. Lavallée was saying and what was also raised by Mr. Rodriguez, especially with regards to a few points that you yourselves, the witnesses, raised. I believe it's you, Mr. Beattie, who stated that we don't want the perfect to be the enemy of the good. And Mr. Del Mastro supported that statement. But nobody can actually attain perfection, but one has to always strive for perfection. And as Mr. Wilson was saying, in this case, the same rules apply to everyone. However, there are different categories of creators that are involved and that you also represent. There are smaller creators, and Ms. Lavallée provided you with some numbers. About $74 million could be lost in copyright to these artists. So when we're talking about striking a balance, especially within the context of technological change, constant technological change, involving different kinds of formats, new formats coming from creators, and creators who can also advocate for themselves and advocate for their own property rights. In that context, we also have to give a capacity to some of these smaller creators who don't have the same amount of control. And there are many analyses that have been done and many numbers that have been provided by experts. And they show that about $74 million could be lost. Mr. Webster stated earlier that purpose of copyright is to reimburse authors or creators. Well, I don't think it's to compensate them. I think it's a payment. It's a salary for someone who creates something. When you create something, it can evolve because of how it's being used or how it's being consumed, and they shouldn't necessarily be compensated, because if you're using that word, then in fact that $74 million is a penalty. And what have they done wrong to lose that money?
Colleagues after that. Let me come back to what you were saying about whether we're allowing the perfect to be the enemy of the good. I fully agree with you. whatever bill comes out of this Parliament, whatever legislation there is, will not be perfect. It'll represent Parliament's best attempt to put a modern regime in place, and it'll start to feel the creaks and strains as technologies change very rapidly. But the only thing that I'm sure of, Mr. Cardin, is that it will be infinitely better than what we have today. And the plea that I would make to Parliament is do not lock us into the 20th century. When we've moved into the 21st century, we need to modernize what we do. And again, I come back to the fact that what can we do for artists? One of the key things that we have to do is to ensure that there's protection in place in terms of copyright to protect their creations. That's essential. Is that all that we can do for them? No, it's not. You know, a former Minister of Communications responsible for culture. There are many tools that government has in addition to address issues that artists have and that it should use. The Société Radio-Canada, of which I was president, is one, the largest cultural institution in Canada and a great source of support for artists as well. There are many tools, but one of the tools that artists definitely need is to have modern copyright legislation. Without that, we lock ourselves in the past. Everybody loses. If we make the change, does everybody win as much as they would like to win? Inevitably, there will be debate on that. The only thing that I know is if we don't act, everybody loses. That's why we must act.
Dans les gens que vous représentez,
you all represent various members, and they include specialists as well. They include experts. They include people who can protect their own inventions and creations. And perhaps we should be drawing on them, drawing on their expertise to help protect the smaller artists. If there were no culture, where would we be? So it's up to them to contribute. It's up to your members to contribute to that protection.
Sheet of the converted, certainly when you're talking to me about where would we be without culture. I've devoted much of my life to defending Canadian culture and Canadian sovereignty, and it's critical for me. What our members are taking important steps. You know, it is our members that create the opportunity for artists to have their works distributed and sold, and who pay them for doing that. It is our members who create the technological protections that are in place to help to protect the intellectual property that artists have created. And we feel very strong. It's a partnership. Our businesses could not function without the creators.
Okay,
it's essential.
Thank you, Mr.
And I would cast the net very broadly. It is not. It's not.
Juste une petite minute,
Thank you, Mr. Beattie.
One brief. I just have.
Move on to Mr. Braid for 5 minutes.
Merci. Thank you very much.
Merci de votre question.
Thank you, Mr. Chair.
Thank you for the question.
Representatives for being here this morning and this afternoon. It's been a very informative briefing and presentation. Mr. Beattie, I certainly appreciated your reference to my riding of Kitchener-Waterloo as an important engine of the national economy, particularly with respect to the high-tech sector, the innovation sector. I wanted to start by asking if you could please underscore and summarize why updating and modernizing our copyright legislation in Canada is so critical for fostering innovation in this country. If you could make that link.
Mr. Braid, I know your community very well. I'm a resident of Fergus, which is where I was born and raised, and which I represented in Parliament, just literally around the corner from you. I'm stunned when I see the creativity in Kitchener-Waterloo and the number of businesses there that have been created, and the number of individuals who just exemplify the best of the knowledge economy. This is where Canada's hope lies in the future, in that sort of creation of new jobs. Intellectual property protection is absolutely critical, whether it's in terms of patent reform or in terms of copyright reform, to reward those people who take risks and those people who invest their creativity. Both people and capital are mobile to an extent unprecedented in the history of humankind. If we do not protect our intellectual property in Canada, not only will we not be able to attract people here from abroad to make those investments of their brilliance and of their financial resources, but we will lose them voting with their feet to go to other countries. And that's why it's so utterly critical. I have a son in university. I don't want him, when he graduates, competing with a young person from Western China on the basis of who will accept the lowest pay. I want him competing on a value-added job based in the knowledge-based sector where we have a sustainable competitive advantage in Canada. And to do that, then we need to have a framework in place, a legislative framework that rewards creativity and that keeps our best and our brightest in Canada.
Thank you. Thank you very much, Mr. Beattie. Mr. Webster, when Mr. Beattie concluded his presentation, he mentioned that the Chamber had some suggested amendments with respect to a couple of areas. One dealt with the issue of reverse engineering. I just wanted to ask if you could share that with the committee, elaborate on that, perhaps provide an example.
Sure. One of the things that we were talking about with respect to reverse engineering is some have expressed the thought that digital locks or TPM should not be permitted to lock down subject matters such as software on the basis that in doing so would prevent individuals from reverse engineering software. Well, I think that digital locks are essential to preserve business and commercial information. There's nothing strange, nothing new about that. That's the way things work in the world with trade secrets. So digitally locking down software code makes just a lot of sense. And the ability to reverse engineer it, why should somebody be allowed to break a digital lock to reverse engineer? Because it's frankly the trade secret or confidential information of the rights holder. Reverse engineering is not, it's a means of copying essentially, and we don't think that digital locks should be broken to allow for that.
Okay, thank you. Thank you very much. Mr. Kerr-Wilson, I wanted to ask if you could please speak to the role of ISPs in ensuring legitimate use, and under C32, the important rights and responsibilities that ISPs have.
Thank you very much for the question, Mr. Braid. So certainly, ISPs under the Act would be obligated to receive notices from rights holders if there's infringing activity, and to pass those notices on to the subscriber in question without identifying the notice or without identifying the subscriber or violating their privacy rights. And then they would also have to retain the records about that, so if the rights holder wants to pursue litigation, there's an evidentiary record. But the fact is, Canadian ISPs, the large Canadian ISPs, have been doing this for a decade with no legal obligation, and in cases where, in the United States and Europe, ISPs have been doing nothing to respond to peer-to-peer file sharing. So in fact, we've been a decade ahead of the curve. France and UK have now developed models that have led them to notice and notice, which is the model that, as I said, ISPs have already been undertaking without the legal obligation, without a lot of formal structures. So it's the appropriate response to peer-to-peer file sharing where the ISP doesn't know what content is on the end user's computer, and quite frankly, we don't want ISPs to know what content's on the end user's computers, but it sends a message, it has an education component, so the consumer knows what they're doing is wrong.
All right, thank you very much. That's going to have to be it. Thank you to our witnesses. We're going to take a short break and bring in our second panel. Thank you very much. All right, we are calling the 10th meeting of the Special Legislative Committee on Bill C32 to order. We have two groups who are going to be witnesses. We have the Retail Council of Canada, Terence Oakey and Howard Knopf, and from the Union des Consommateurs, Anthony Haymon. So we will start with Terence Oakey from the Retail Council of Canada for 5 minutes.
Okay, great. Thank you, Mr. Chairman. The Retail Council of Canada is pleased to provide our comments on Bill C32. As you stated, my name is Terence Oakey, and I'm a Vice President with the Retail Council of Canada. Our members speak for an industry that touches the daily lives of Canadians in every corner of the country, and one that directly contributes close to $75 billion in GDP, invests $5.9 billion in infrastructure and machinery, $1 billion in logistics, and is also quickly becoming the #1 job-creating sector in our economy. Our industry is innovative and highly reliant on emerging technologies with one goal in mind: to deliver the highest quality product and service to the customer in the most cost-effective manner. Our members sell the very cultural products that this bill intends to protect, so it is in our members' interest to advocate for the best balance between the public and consumer interest on the one hand and the interest of creators, producers, and distributors on the other. RCC has always taken this approach, whether before committees such as this or before major court cases relating to some of the issues that I will deal with today. I want to focus briefly on 5 issues in my opening remarks, and I believe that members of the committee have our submission, so more detail is provided there. The first issue I want to deal with today is the levies, or as some have referred to it as the iPod tax. Even though it is not addressed specifically in the bill, the issue has loomed large in the public debate around copyright. Our members feel that there are good reasons to ensure that the blank media levy is not extended to iPods and actually should be repealed altogether. We believe the tax is obsolete. There is nothing like it in the UK or Australia, and most importantly, the United States, where most of our retailers compete head-to-head with US-based retailers. If it is expanded to iPods, we believe it will creep to cell phones, Blackberries, and even computers, and will drive sales away from Canadian retailers. Although there is persistent denial by iPod tax proponents, the fact is in SOCAN's most recent attempt at the Copyright Board to impose a levy on digital audio recorders, they asked for an amount of $75 on each recorder with more than 30 gigabytes of memory. In other words, that would cover basically your classic iPod. And we know now there's many devices that have 3 times this amount of memory in their capacity. This tax would put Canadian retailers at a significant competitive disadvantage, and I would argue would simply further incent Canadians to buy their devices outside our borders to escape this fee. Our next issue is parallel imports. RCC is concerned that Section 4 of the bill may inadvertently affect the abilities of retailers to bring in parallel imports of legitimate and competitively priced goods from abroad. This practice of parallel importation is expressly permitted by the 1996 WIPO treaties and other World Trade Organization agreements, and is seen by consumers and retailers as being an indispensable tool in the maintenance of free trade, competition, and the prevention of international price discrimination. We do not believe that the government intended to change the status quo, so we suggest that this provision either be omitted or that the bill be amended with improved wording that would maintain the status quo. And in our more detailed submission, we provide such wording. Our next issue is fair dealing and exemptions. We believe, or our members believe, that the performance of music for the sole purpose of demonstrating any consumer electronics device or selling CDs or DVDs should also explicitly be included as an exemption in the legislation. This would be perfectly consistent with long-standing American legislation that deals with this precise issue. It would also be consistent with the fact that iTunes now can show or sample a song for up to 30 seconds without paying this fee. This is yet another example where bricks and mortar retailers are at yet another competitive disadvantage compared to their major trading partners. Our next issue is photo finishing. As many of you are aware, today's inexpensive high-tech cameras allow almost anyone to take pictures that look somewhat professional. Some of our members are becoming concerned and are refusing to make prints because they fear of being sued under statutory damages, which can be as high as $20,000 for each photo. This bill should include an explicit exemption that immunizes any commercial photo finisher who acts in good faith and relies on the written representation that the customer has the right to request the reproduction. Our next issue is technical protection measures. We join the chorus of many manufacturers of consumer electronics and many artists themselves who believe that overly rigid measures to protect digital locks are bad for artistic creativity, bad for innovation, and bad for the retail business. Consumers should be free to do whatever they want with their legitimately purchased hardware and software as long as that use is for private purposes that are otherwise non-infringing. That is all that is required by the WIPO treaties, and we believe that that is as far as Canada should go. With that, that concludes my opening remarks, and we'll be happy to, Howard or I will be happy to take your questions. Thank you.
Thank you. We'll move on to Monsieur Aymon.
Je souhaiterais remercier le comité.
Thank you, and I'd like to thank the committee for inviting me here today to speak to the copyright bill. I am Anthony Aymon, and I am a lawyer for an analyst in telecommunications. We have raised several issues with the bill, the rights provided to users and the accountability on the part of Internet service providers. The bill goes beyond the simple protection of rights that authors have. It allows authors and users to limit, through technical protection measures, the rights that users have. It should be pointed out that there are various treaties, including WIPO, that do not include TPMs that protect access to works, and it limits these measures to only certain works. There are some European countries that have ratified these treaties and organizations that have chosen to not include within those technical protection measures the ability to bypass locks that protect access to works. Therefore, it is possible to ratify these treaties without including technical protection measures that infringe on users' rights. We believe that Canada should use the approach that has been used in the Swedish Copyright Act. That approach protects both the existing rights of right holders and the public, and it strikes a balance that Canadian legislation should also strive towards. That is, a balance between the creators and the right of the public. According to some people, technical protection measures that control access by the user to certain platforms control their access to platforms that are necessary to them. The Copyright Act does not have as a goal to protect business models or businesses necessarily, but to give authors certain rights and obligations while striking a balance between their rights and the rights of the public. These technical measures that control access to works, we think, should not be included in the Copyright Act. If we're talking about business models, those should be in different legislation. So we are proposing that the bill be amended in order to modify the definition of technical protection measures and to allow the bypassing of those measures when they limit the rights of users. There are also new exceptions. We welcome the new exceptions, that is, the reproduction for private use, ephemeral recordings, and backup copies. These new exceptions make legal certain practices that are already broadly used by consumers. These are practices that are supported by the market and that have been provided for a long time now. The clauses for these exceptions should, we think, be amended. There are certain conditions attached to these exceptions that might be inappropriate or impossible to apply, and we don't think that they necessarily reach the goal that they were focusing on. Furthermore, we don't think that some of the conditions are justified. The wording of these clauses, we think, are too confusing to the user and will limit their own understanding of the rights that they have. We think that these should be simplified so that everyone can understand what is allowed and what is restricted. For example, there should be, in one article, one provision, the right to private copying, the right to backup copies, the right to fixate a signal, for example. We think that this would be possible and is preferable. The witness is reading his brief much too quickly for the interpreter to follow.
said that you're reading too quickly for her to understand.
Okay.
We think that a new system should be neutral and should allow all creators to be paid for their creations and for users to be able to have legal certainty. We don't want them to live in a situation where there is uncertainty about whether or not they have the right to copy a work or not. There's also the issue of accountability on the part of Internet service providers. Some right holders feel that the bill should impose on Internet service providers the obligation to pay for everything that is on the Internet. They would like IPS providers to pay for everything. Now, if Internet service providers have to pay these kinds of rights, then obviously that would increase the cost of using the Internet. In other words, all users, whether they are involved in infringing activities or not, would have to pay. And that means that more illegal acts would be encouraged. If we are going to have any system of levies or royalties, then there should be something that is logical and fair. It would be strange to propose a system that on the one hand would lead to more infringing activities by users who would have used the Internet legally but would end up having to use it illegally, and to have a system that compensates those who have already been using the Internet illegally. We would like there to be a licensing system.
Questioning.
OK. C'est pourquoi nous encourageons la mise en place d'une licence pour la mise à disposition des œuvres sur les réseaux payés par les utilisateurs. Une telle approche nous semblerait plus efficace et plus viable et plus équitable. Merci.
Okay, merci. We'll move to the first round of questioning. Mr. McTeague for 7 minutes. Thank you.
Yes, I'll promise not to be very fast in my questions. Merci à tous les témoins qui sont venus ici.
Thank you to all the witnesses that have come here today.
Credit cards and other issues, and I've always known you to be a very solid individual and organization that has a great reputation. And I certainly wouldn't want the organization to give perspective to an ideal about iPod taxes or levies that are those of the Liberal Party. As you know, Mr. Oakey, we do not support that. And despite the conservative attack ads, which tend to be nothing less than a prevarication of the truth, the reality is that we don't. I think you understand that.
Yes,
is that
I
correct?
do. Yeah, I've met with Mr. Garneau and Mr. Rodriguez as well, and I've been assured of that.
Mr. Oakey, I'm very interested in the RCC's take on copyright in general. I know that you were very helpful in 2006 when the Industry Committee came to a number of conclusions which led, I think, to part of the legislation that we have before us today. I must say that I'm somewhat pleased to hear the endorsement, the support that you have for TPMs and the position that we've taken. Within your own membership, do you have concerns about the illegal use or the sale of products? This is something that I recall hearing at one of the speeches given some years ago, that there was a sort of, within the organization itself, within the RCC, an attempt to at least curb the incidence of copyright infringement, particularly the more egregious natures.
Absolutely. I mean, our industry depends on those consumers who buy legitimate products. And we are the first ones to want to crack down on piracy and other uses of the product that are illegitimate. That being said, a lot of our members have expressed concerns about digital locks that might go too far in terms of a customer expectation. So we want to ensure that there's a scenario where customers are incented to buy legitimate products. So when they buy a DVD at one of our member stores that's completely legitimate, and then they maybe go on vacation to Europe and can't use it because of a TPM that's on it, a lot of our members feel that that's an incentive for the customer simply when they go to Europe to find a site where they can download the movie that way, and that becomes a practice.
Because in the interest of time, I wanted to flesh out more of your comments on parallel importation and give us a real example of how this is impacting your membership.
Sure. Actually, I'll ask Howard to talk more about that.
Thank you, Mr. McTeague. The best example I can give is the one that was in the Supreme Court of Canada 3 years ago, in which Retail Council of Canada intervened. Kraft, a big multinational Kraft, tried to use copyright in a highly technical way to block the importation of perfectly legitimate Toblerone chocolate bars from Europe that were coming in at a lower price, because they said there's copyright in this little logo, tiny little logo on the chocolate bar. And Justice Binney, in his usual brilliant and witty way, asked the lawyer for Kraft if this was really about artistic creativity, which the lawyer for Kraft said it was. And he said, Justice Binney said, "Do you seriously think that anybody's going to buy this chocolate bar, frame the package, and throw away the chocolate?" And the answer was, of course, was a rhetorical question. That's what parallel import law is all about, is to use copyright in a very technical way that has nothing to do with the product in most cases, and is designed to achieve price discrimination and eliminate competition. So we've come up with what I think is a very simple amendment that we've given you that would combine both. There were several opinions in that Supreme Court case. We would combine the two prevailing opinions, the one rather technical one having to do with hypothetical maker, which you don't want to hear about, I'm sure,
right, yeah.
and the other having to do with what Justice Bastarache called an incidental use. So if the incidental use of this little logo on the label is incidental to the chocolate bar, which is the real object of the transaction.
It sounds to me, Mr. Knopf, it's a very interesting point. It's a point that a good number of our friends in the bar might understand, but I'm wondering how this directly impacts your members, and I think that's really the concern we have, is that if your members are expressing this is there is a cause and effect. Right. It's well known. Then it's certainly something we'd want to look at. In the interest of time, because I know I'm going to get gavelled here in a second, Monsieur Aymon, simplement une question sur les dommages.
Just one question for statutory damages and penalties. Are you satisfied with the kinds of penalties? Are you satisfied with the fact that this will act as a deterrent to piracy under this proposed bill? Under the proposed bill, there are mechanisms that are being suggested that we feel are effective and that actually are already being used by ISPs. So the bill really only puts in law something that is already being done. You stated that you're concerned about levies or royalties. Could you please go into that in some depth? I think I don't think that was very clear. Well, what we are suggesting is that there be one system for making copies instead of several. For example, ephemeral recording with certain conditions, because those conditions really can't really be applied as they're being proposed in the bill, whether it be in private homes or elsewhere. It would be impossible to implement those conditions. And so if it's not possible to do it, then the user doesn't know whether they're doing something that is legal or illegal. So we need a system that applies to everyone in every situation. It would be very simple. There would be a symbol of levies that would be taken, and it would allow all users to make their copies. Well, how would you do that? How would you do that? Well, there are systems that can be used. For example, the United States and the UK have done this. There are European countries that have levies for private copying. Their systems work fairly well. Now, before the courts have determined that individuals have the right to make private copies.
In the few seconds that I have, your take on the statutory damages and whether or not they in fact encourage more egregious behavior by simply placing a monetary penalty of $5,000. Are you going to be able to, and you have members obviously who are in the retail industry who may be affected by this, how are they going to stop the ISO hunts and the BitTorrents of this world who are stealing information and with very little legal impact, let alone a remedy as far as penalty is concerned?
Mr. McTeague, as Mr. Oakey said, the RCC in no way favors piracy in any way, shape, or form. I think that $5,000 is a lot of money for most Canadian households. It's about a year's tuition, as I understand these days, at university. It's enough to make people notice. Some people think that it should be eliminated. Only Canada and the United States, amongst major countries, even have statutory damages regimes. So we do have it. We're not in any sense proposing its abolition. But $5,000 is a lot of money for most families.
who may be making tens of thousands a day doing what they're doing, illegal in Canada, illegal in other jurisdictions.
Mr. McKeek, that's a completely different issue. It has nothing to do with this issue. They do not get that exemption.
Mr. Knopf, Madame Lavallee, you have the floor for 7 minutes.
Merci beaucoup. Thank you very much. First, I'd just like to point out that you in the Retail Council provided us with a brief and stated in that brief that royalties might represent about $75, and that is an indisputable fact. But I'm sorry, but I do dispute that fact. I went to the link that you provided, and I saw that this wasn't the amount that was being suggested. It was a draft, a proposal. And later, I'm happy to actually give you that information that I got from the internet. But a decision was made on $25. Now, you're calling this a tax. As you know, you're perfectly intelligent. Everybody else around the table is. A tax is money that goes to the government. Royalties go to a private business or association that is given then to the artist. So it's rather surprising then that the government doesn't want to provide royalties, but that it does want to come into Quebec and tax our books. But anyway, my question is for Mr. Raymond. I'm happy to see you here today. I have 2 questions to ask you, and we'll keep a bit of time for afterwards, because I want to talk about music and Chapter 8. You spoke about private copying, and you said this is a system that already exists elsewhere in the world and that works. I assume that in some countries it works well. Here in Canada, it has worked well. But from the point of view of consumers, you represent consumers, if you were going to redo that chapter, what would you apply those royalties to, and on what works? Would you focus on music? Would there be a ceiling? Copyright Board set $25, for example, but would you set a ceiling? And if we did have that system, what would the advantage be to the consumer? And just remember to leave me 30 seconds at the end. Well, consumers, I think, support this. A poll was undertaken and was tabled with this committee, and it shows that consumers are willing to pay those levies. Now, what should it apply to? Well, any equipment that allows you to make a copy. There are users who have made copies, who have already made copies, and they need to be reassured. They need to know whether they've been involved in an infringing activity or illegal activity, and they need to know what those levies will apply to. So we need to reassure people who are making these copies for private use. This is good for the consumer, and it's good for the artists, because consumers know that they're not engaged in illegal activity, and they're encouraging creation at the same time. Now, what kinds of work should this apply to? I would say that it could extend to many works, to all kinds of works, actually. You mean it could apply to literature, visual arts? Yes, why not? If I buy a book in a store, I can lend it to my wife. If I buy a book online and I put it on my iPod, I can't really lend it unless I lend out my iPod, because there are digital locks that prevent that. So it's not at all the same situation. The users then are limited in their use. So the system has to be reviewed and revised, taking that into account. So you would apply those levies to any digital equipment, and iPads, cell phones, USB keys. No, USB keys, I'm very aware of what other countries are doing with respect to private copying. For example, in France, they want to tax GPS systems. That's quite shocking. So you can go too far, and you mustn't, because if you go too far, then that will be rejected by the consumers, and then they will be pushed towards engaging in something that may be illegal. Who knows? Because they would be fed up with having more and more taken away from them. So we have to reassure them. We have to reassure them that it only applies to certain works and certain equipment. Now, with respect to the amount, the Copyright Board is doing remarkable work, and it should be pointed out that the amount that is being proposed might have to be reviewed and revised because conditions have changed. But that's something that the board has to debate. Then are you talking about the possibility of copying? Well, everyone has to be able to do this. Copies can be made more and more, and it can be controlled too, and it would be unrealistic to try and control all of it. So let's find a system that's a win-win situation for users and artists. With respect to streaming, could you tell us how artists could obtain royalties? How could artists be paid with respect to streaming? And how could we have access to that streaming? How could the service provider deal with this? Well, what's being proposed are subscriptions, for example, to systems that don't exist yet in Canada. Deezer in France is one system. So there's advertising, for example, that's used in order to allow this to be free. There have been more or less, there's been progress in these areas depending on where you are. Well, could you draw a parallel between, say, radio or listening to music over the internet without paying? Could you compare that to streaming? Well, yes, there are similarities. And radio and streaming, yes, are comparable. But the difference is that the user has control over the streaming because the user can choose the music they want to listen to. So there is that ability to interface with it. But there are certain similarities with radio. And if there have been levies or royalties in the past, well, it's because people were recording what they heard on the radio and then using it. I read some of the briefs that have been presented, and I saw that subcommittees actually were doing work on this in the 1980s. And they used royalties and levies when people were recording works for use in their own home, and that's perfectly relevant today, because that is a win-win situation for users and creators.
For 7 minutes, please.
Thank you very much. Once again, fascinating discussion. Mr. Oki, you were correct on one element on the levy. The United States doesn't use a levy. You're absolutely correct. They sue people. 100,000 people last year alone sued in the United States. They don't actually get to court. They just get a thing in the mail, give us $5,000 or we'll sue you for $1 million. So that's not exactly consumer friendly. You didn't mention that many European countries use the levy, because the levy has been found to be a balancing act. And it goes back to the days of the cassettes, when they started to notice that the music revenue was starting to drop off because people were making numerous copies. Now, as a musician, I never had a problem making copies. Nobody makes more copies of musicians because we love music. It's not about dinging people and shutting them down, but it's finding some balance. So the question is, you threw out the $75 fee that my colleagues over there just love to run with, and yet I look at the Copyright Board's decisions, and it seems completely at odds with the position you're taking. When it was applied to cassettes, it wasn't market distorting. When it was applied to CDs, it wasn't market distorting. Sure, we heard people complain. I used to hear people say, I've never made a copy. I'd never make a copy. Why should I pay the levy? I mean, I never met so many digital virgins in my life. But the fact is people are making massive amounts of copies. So when it came before the Copyright Board, sure, the rights holders are going to start up as high as they want. The Copyright Board adjudicates. It makes them go through it. It tests them. So you could start with $75 and they could bring it down to $5. Because one of their decisions is going to be it has to be based on what is the intent of it. So, for example, James Moore had said that the iPod levy would be applied to cars now. Well, it wouldn't be applied to cars because you don't buy a car to record a song. If you do, you've got lots of extra dough that you probably shouldn't have anyways. It's applied to music players. Now there's many other forms out there right now. There's people got phones and everything else. But the Copyright Board was very specific. It had to be marketed as a music player. That's it. And it was very limited in what it was. And the Copyright Board also makes it clear that it is not going to be market distorting. And the other element is say, for example, iPods drop from $300 to $59, and we have a $10 iPod fee on it. It's within the minister's power to change it to a percentage or change it to whatever dollar figure he wants so that we ensure it's market distorting. So for you to come here and say, this is going to be $75 and it's going to drive people to the United States. Did you ever see people driving down to the United States to buy cassettes?
No, I didn't say it was $75. I said that SOCAN asked for it to be $75.
But you seem to leave the impression here that
And
you
that's
thought
at
that was
30
bad
gigabytes.
and it would be market distorting.
Absolutely,
Whereas when the
we think it would
Copyright Board adjudicates, they're not going to take SOCAN's word. They're going to say, what is the market, what's a fair market price? That's how the Copyright Board works.
Yeah, we think that a levy on iPods or similar devices would be market distorting because it isn't in the United States where Canadians can easily go to an online retailer that's based in the U.S. and buy their iPod there. So I would argue artists would likely receive less money because in the end, more people are going to buy their products in the U.S.
But the levy wasn't market distorting on cassettes. It wasn't market distorting
well on a
CDs.
blank CD, what was it, 23 cents?
29 cents.
29 cents. And in the U.S., a blank CD retails for about 15 cents.
So
if
do you think
call
people
that
went to Buffalo to buy CDs?
I'm saying that that's obviously market distortion.
Well, I think you're incorrect there. And I think the issue of finding a way to do some form of digital remuneration has to be addressed. Or we have to go to the issue of suing people because there's no in-between. Or we go to digital locks. The conservative position is we're going to take out the remuneration, but we're going to put locks on it so you can lock down your content. And I think that that's going to lead people to piracy because, you know, when I drive down the highway and I get a cup of coffee and that cup of coffee stinks, I don't take it up with the rights holder, the coffee maker, like our previous witness. I leave and I go to another coffee shop. And when I talk to young people, and they find a product, for example, my daughter tells me the last CD she ever bought had a digital lock and she couldn't back it up. She said, $25, Dad, that's the last CD I ever bought. She went out and downloaded the entire album, felt it was her due. And I talk to any young people, if it's not easily accessible, they will get it. So the question is, we move to digital locks because it's the only solution if we don't have remuneration. So how do we find that balance to say access and remuneration? People have to get paid. Otherwise, you're going to put a lock on it to keep people from stealing it.
You want to go ahead and address a more fundamental issue?
Or maybe we wait for the industry to develop a new business model after all these years.
But Mr. Knopf, we've been waiting for it for 15 years. Unless you have a monetizing stream, there's no business model.
In Canada, the industry has come to rely on this revenue stream. By their own figures, it generates, by their own figures from the CPCC, it generated about $160 million over 10 years distributed to 97,000 copyright owners, many of which are large publishers. What that means is that the average musician who got a check, and that leaves out most of the emerging artists, the average musician who actually got a check got something considerably less than $160 a year. Okay, which isn't very much money. I used to be a musician too. We both know that musicians like to drink beer, and $160 doesn't go very far these days.
I know, but copyright, like, it sucks being a musician. Well, nobody's arguing that. Nobody's arguing that they only get $160, but it's their right. And I mean, I hate to be the socialist here saying I don't have a problem with Bono getting millions, but copyright is based that if you sell a lot of songs, you make a lot of money. And if you're a working musician and you only get $160 check every quarter, and sometimes it's that, and sometimes it's $5,000, you still have a right to get that. So I don't see how the new business model is going to appear if we say, well, go out there and find a new business model if there's no way to be remunerated. Either we do a levy on the product, or we're going to do a levy somehow online in the way that they monetized radio in the 1930s. But you're going to have to come up with a revenue stream, otherwise selling T-shirts ain't going to cut it.
Well, Mr. Angus, in UK, Australia, in the United States, there is no levy. And yes, there are lots of lawsuits. Those mass lawsuits are being thrown out by the courts, right, left, and center. And there will be
They
a way
just
to...
went after Gemma Thomas again for 1.5. She's been in court
No.
3 or 4 times. The vast majority don't get to court because they're afraid to, because they're going to pay the $5,000 fee to RIA rather than mess with them.
Nobody's encouraging that, but if we put in the levy that the music industry wants, the inevitable consequence is that you legalize all kinds of downloading, which many in the industry would consider to be piracy. That's why the industry itself is so badly split on it.
No,
the recording industry
the four big labels that represent the U.S. labels are against it. Pretty much every other independent music company and organization in the country supports it because they recognize that it's a revenue stream. So we're not legalizing piracy. We're saying copies are being made. Nobody's getting paid. And we can shut down ISO Hunt, but people are still not getting paid. And that's the question. We have to find a model to somewhere along the line to say that for all the monetizing out there, all the access, someone's going to get paid at the end of the day. And I don't see that coming from the suggestion, well, consumers are going to go to Buffalo and buy an iPod cheaper. It's not a reality.
Thank you, Mr. Angus.
Thank you.
We'll move on to Mr. Lake for 7 minutes.
Thank you, Mr. Chair. And this is finding this discussion incredibly interesting today. There's a lot of ducking and weaving, I think, on the part of the Liberal Party to because of some things that they've said in the past or done in the past regarding the iPod tax. I find it quite interesting hearing particularly the strong language from Mr. Garneau last meeting and Mr. McTeague this meeting regarding their position, because the facts are the facts, and you only have to look at the facts to see that, well, first of all, the Copyright Board did propose the iPod tax that would be in the range, as you mentioned, $75 for anything more than 30 gigabytes. And, of course, that covers most recording devices that we would use that are commonly used now. So very, very significant. And, of course, a 30 gigabyte device probably in this, you can probably get one for $150. So $75 tax on top of that is pretty significant. In regards to the specific issue and the language that Mr. McTeague and Mr. Garneau used today, let's just, again, take a look at the facts. In March of 2010, the Standing Committee on Heritage reported a motion to the House. Okay, and the motion read, and it's important to hear the wording used in this motion. The motion read, quote, that the committee recommends that the government amend Part 8 of the Copyright Act so that the definition of audio recording medium extends to devices with internal memory, so that the levy on copying music will apply to digital music recorders as well. That's pretty clear. It's a pretty clear motion reported to the House. On April 13th, the House voted on this motion. This is the official record of the House of Commons, the official record of the House of Commons. So this is the final vote on this issue in the House of Commons in April of 2010. And the vote went... I've got a list here of the yeas, and I see Mr. Angus, that's not a surprise. Mr. Cardin, not a surprise. Mr. Garneau, yay, he voted yes to that motion. Ms. Lavallee, of course, not a surprise. Mr. McTeague, the official record of the House, you voted yes to that. You voted yes in the House to recommend that the government amend Part 8 of the Copyright Act so that the definition of audio recording medium extends to devices with internal memory, so that the levy on copying music will apply to digital music recorders as well. So you can't possibly, Mr. Schellenberger, actually, if I go down the list here, voted no. So every Conservative member voted no. So just taking a look at the facts, that's the official record of the House. We actually had a vote on the issue. So it's pretty hard. In fact, actually, I've got a quote here from that day in the House where Mr. Rodriguez was quoted as saying, "We are in complete disagreement with the Conservatives when it comes to taxes. We consider it a levy." So he's not opposing the issue itself. He's opposing maybe the wording around it, but clearly in favor of the iPod tax. So the record is there. You can't argue otherwise. You voted on it not that long ago. So we're talking about $75. I want to get back to the actual issue at hand, if I could, with Mr. Oakey. $75 on a $150 device, for example. Now, I'm from Alberta where we don't have a sales tax. I personally avoid buying things here because I don't want to pay 8% more. $75 on a device that might cost $150, that's a 50% tax on top of the device. Is it reasonable, for example, that when a Canadian knows that they're going to go to the U.S. at some point in the near future, that they might not buy something that's going to cost them $225, knowing that they can get it for $150 in the States when they're there.
Right. This is a concern that our members have obviously expressed. That's why I'm here expressing it to you. But it also has to be looked at in the holistic environment right now, where the dollar is at parity. There are already other requirements that Canadian retailers have to adhere to that their U.S. counterparts don't. So it's a competitiveness issue. So obviously, I think, and our members think, and they've seen it. Just the dollar going from 95 cents to parity is leading customers to buying online. I mean, that's not even an 8% difference. So I think obviously if there's a tax on iPods, anywhere near what the Copyright Board or SOCAN or Resound is asking for will lead to Canadians buying their products outside of our borders to avoid the unnecessary fee.
Do you think it's reasonable that comparing two prices, one at $225, one at $150 for the same product, even if someone's not planning or able to go down to the U.S., is it reasonable that that more people would buy a product at $150 than would buy it at $225?
It's reasonable to assume that, but there's another point. You don't have to go to the U.S. You don't have to travel across the border, buy your iPod, and bring it back. You can ship iPods into Canada duty-free and just pay the GST. So if there was that difference of price, it may make sense to even buy if you were going to your winter vacation to buy one, but you can also buy one online.
Right. Mr. Himon, do you want to jump in on this conversation? Do you have any thoughts on that?
Oui, effectivement, si on regarde.
Yes. If you look at other countries, for example, in Europe, where there are levies, people go, and there aren't very many people who go abroad to purchase devices. Because if you buy, for example, a piece in the United States, where's your guarantee? So there are companies who may say, well, no, you purchased it in the United States, so I'm not providing you with that service. So Canadian consumers also have an interest in purchasing those devices in Canada.
Side of the argument, what are your thoughts on that?
Well, in terms of the warranty, there are issues, but it depends on where the price point is. If it's, a $75 additional fee and $150 is quite substantial. I would argue that if someone feels confident with the product, which most people do about digital music recorders, they likely would take the risk of their warranty.
I guess I want to now, if I could just move with the final bit of my questioning here. We'll hear a lot of discussion about what people don't like, and I've said this meeting after meeting when I'm talking to folks. What is it that's the most important part of the bill? What in this bill would you say, as we're discussing what to potentially change or alter as we go through this, what are the areas that are the most important to maintain in the bill?
Right. The number one issue for our members is that the blank media levy on iPods not be extended. That is our number one issue, and I know it's not directly addressed in the bill, but there are rumors that there may be amendments coming. So our members have told me that that is our number one issue and focus on that.
Okay. Mr. Himon, in terms of the bill, the things that you like in the bill, what are the most important parts of this legislation that you want to make sure that we protect as we go through the discussion?
Well, there are some very interesting parts to the bill with respect to the new exceptions. Those are the rights for users. But one point that I would like to be amended are the technical protection measures, because as currently defined, they are extremely problematic for users. And what...
We're going to hear that repeatedly. We've heard it already. But what I'm interested in hearing from you today is the things that you want to make sure that we protect in the bill, the things that are the things that you like the most about the bill.
Mr. Lake, that's going to have to be it for your round, and with the consent of the committee, we could go for a 2-minute round for each of the parties. Okay, we have consent. Mr. Garneau for 2 minutes.
Thank you very much, and I'm glad, Mr. Oakey, that you said in response to Mr. McTeague that you recognize the Liberal Party had no intention of putting any kind of levy on iPods, and that you'll be ignoring the 5-minute rant from my Conservative colleague on that, which is completely disconnected with any sense of reality. But my question to you is this. You had talked about the fact that people for private use, when they've bought something, should be able to use it do some format shifting, perhaps copy it, back it up, that kind of thing. Do you have, in terms of the legislation, the proposed legislation, a specific way that we could do this? Because this certainly is something that many groups have said is the right thing to do, and I agree with it, but is there a practical way that we can do this through the legislation?
Right. I think there is. We do believe that they may be on the side of owners for consumers, but Howard, I think, is going to comment more specifically as we do propose it in our submission.
We have not specifically addressed that in detail, but we'd be happy to provide something later. What we do propose, what we have specifically addressed, is some very simple language to, pardon the expression, liberalize the TPM regime that would probably allow exactly what you're suggesting to happen, so that a consumer can break a digital lock or whatever to make a copy for the car or the bathroom or the cottage or whatever, which doesn't cause economic harm because the consumer has already paid for it at least once already.
Okay, thank you very much. I'd appreciate getting that. I don't think we have your submission here in front of us yet, but thank you.
Thank you, Monsieur Cardin, for 2 minutes.
Merci, Monsieur le Président. J'aimerais demander.
Thank you, Mr. Chair. I'd like to ask Mr. Raymond the following question.
Ça serait-il possible avant?
Would it be possible?
If there's any submission to give that we actually have them on our tables here. I didn't know we did not have it. I don't want to make a big deal of it, but it's important that we've got witnesses here. We didn't have some of these submissions. Thank you, Chair. Excuse me, Monsieur
Cardin.
Merci, Monsieur le Président.
Thank you. I'd like to put a question to Mr. Raymond with respect to streaming. Who do you think should be paying levies for streaming? For streaming, I think the model would be the one I mentioned. There should be agreements between those who want to provide that streaming and between the creators, because you can't necessarily record all streaming, so the user only listens to that music. And there have been models that have been proposed. For example, advertising could support the cost of that. So there are any agreements, levy agreements, could be between the creator and the person providing that service. With the remaining time, would you like to add anything? Is there anything you would have liked to say that you didn't have an opportunity to already state? Well, I've heard it stated that the United States don't have a levy system. They did have one in the past that applied to digital cassettes, and they tried to implement it to the ancestor of the iPod, the Oreo. So you have to be careful on the message you give about Americans. They have used levies. They didn't succeed, but they do have a system, and it doesn't necessarily apply to iPods, but they did have one. Levies are a win-win situation for the user and the creator. So, and be careful about the technical protection measures. I'd like to emphasize that, because there is a definition in the bill, but it goes way beyond what other treaties have proposed. And we have in our brief proposed amendments to that definition, because we feel that it's more than just a lock. It's a lock on all of culture.
Thank you, Mr. Chair. And again, sorry, I have to come back. Mr. Garneau used the words completely disconnected from reality to refer to my reading from Hansard, the official record of the House of Commons. And I just find that astonishing. We have the official record of the House of Commons where, again, we voted on this statement, that the committee recommends that the government amend Part 8 of the Copyright Act so that the definition of audio recording medium extends to devices with internal memory, so that the levy on copying music will apply to digital music recorders as well. That was a statement that we had a vote on April 13th, 2010. And when we had that vote, members of Parliament voted, and every single New Democratic member, every single Bloc member, every single Liberal member, including Mr. McTeague and Mr. Garneau, were recorded on the official record of the House of Commons, Hansard, as voting yes to that motion. Every single Conservative member voted no to that motion. It's very, very clear. It's the official record of the House of Commons. You know, if we're going to talk about being completely disconnected from reality, I'm just trying to make a connection to the official record. And the official record says that all three opposition parties are in favor of the iPod tax. And it's very, very clear. So as we work our way through this legislation, the way to change that reality is to pass a copyright bill quickly, a copyright bill that does not include an iPod tax. That's the way to disconnect from the reality of the way that they voted in the past. And when Mr. Angus's bill comes up, which is a bill to introduce such a tax, they will have the opportunity at that point to again prove that they're not in favor of it by voting that way. And we'll see what happens at that point.
Thank you, Mr. Lake. Meeting adjourned. Thank you to the witnesses.